Imagine you're in a serious car accident tomorrow. You're alive, but you're in a coma. You can't talk. You can't sign anything. You can't tell anyone what you want. Now, who pays your mortgage while you're in that hospital bed? Who talks to your insurance company? Who manages your bank account so your bills don't pile up and your credit doesn't collapse? And separately, who tells the doctors whether to approve a risky surgery? If you haven't answered those questions in advance with the right legal documents, the answer might be nobody. At least not without a judge getting involved. And that process takes time, costs money, and may result in someone you never would have chosen making those calls for you. I'm Dr. Bunchessa. I'm a physician and I've watched these situations unfold in hospitals. Families who desperately wanted to help a loved one but didn't have the legal authority to do anything. Not because they didn't care, but because the paperwork wasn't in place. Today, I'm going to break down the different types of power of attorney, what they are, how they work, which ones you need, and why getting the details right matters more than most people realize. Quick disclaimer before we go further. This video is for educational purposes only. It is not medical, legal, or financial advice. Laws vary by country and by region, so always consult a qualified attorney, healthcare provider, or financial advisor in your area before making legal decisions. Now let's get into it. What's a power of attorney? At its core, a power of attorney is a legal document that lets you, while you're still healthy and capable, choose someone you trust to make decisions on your behalf if you can't make them yourself. You are the principal. The person you choose is your agent or attorney, in fact. The titles change depending on where you live, but the concept is the same everywhere. Now, before we go any further, I need to explain something that confuses a lot of people, and getting this wrong can cause real problems. There is no single power of attorney that covers everything. There are two entirely separate lanes, and they serve different purposes. Before we go deeper into the types of POA, I want to consolidate some terminology. Different countries and states use different names for these documents and the people involved. Your agent may be called an attorney in fact, a healthcare proxy, a surrogate, or simply your attorney, depending on jurisdiction. What matters is the function, not the title. And I want to explain the concepts of capacity and competence because they're central to how all of this works. Capacity is clinical. A physician assesses whether you can understand, reason enough, and communicate a specific decision. It can change from day to day. Competence is legal. A judge formally determines whether you can manage your own affairs. When a court declares someone incompetent, that person loses the legal right to make certain decisions. The whole point of setting up a power of attorney while you're healthy is so that a court never needs to make that determination for you. The two lanes, medical versus financial. The first lane is medical power of attorney, sometimes called a healthcare power of attorney, a healthcare proxy, or a durable power of attorney for healthcare. Depending on your state, the names vary, but the purpose is the same. You choose someone you trust to make medical decisions for you when you can't. That includes consenting to or refusing treatments, approving surgeries, communicating with your doctors, accessing your medical records, and making end-of-life decisions based on your wishes. The second lane is financial power of attorney. This covers your money, your property, and your legal affairs. Your agent can manage bank accounts, pay bills, handle investments, file taxes, conduct real estate transactions, sign contracts, represent you in legal proceedings, and manage insurance claims. Legal authority, like signing contracts or dealing with lawsuits, fall under the financial umbrella. These are separate documents. You can name the same person for both, or different people. Maybe your sibling in the medical field handles healthcare decisions while your financially savvy sibling handles your accounts. Most estate planning professionals recommend having both. Now, within both of these lanes, there are choices about how the document is structured, and this is the part that confuses people most, so I'm going to lay it out clearly. When does your agent's authority begin? Both medical and financial POAs can be structured in different ways, depending on when you want your agent's authority to kick in. A durable POA takes effect as soon as you sign it and remains in effect even if you become incapacitated. That's what durable means. It endures through your incapacity. This is the most commonly recommended type for both healthcare and financial planning because there's no gap in coverage. Your agent has authority from day one, and it doesn't disappear when you need it most. Now, when people say durable power of attorney without specifying healthcare or financial, they're almost always referring to the financial version. But the durable structure applies to healthcare too. In fact, many states title their healthcare form Durable Power of Attorney for Healthcare. It's the same activation principle applied to medical decisions. A springing POA doesn't take effect until a specific triggering event occurs, usually a physician's determination that you've lost capacity. Your agent has no authority until that moment. This structure is available for both financial and healthcare POAs in many states, though it's more commonly discussed on the financial side. The appeal of a springing POA is that you maintain full control until you genuinely can't. But in practice, it creates problems. The determination of incapacity can take days or longer. If the determination in your document is vague, disputes can arise about whether the trigger has been met. And some states no longer allow springing POAs at all. Most estate planning attorneys recommend durable over springing for this reason. A springing durable POA combines both. It doesn't activate until the triggering event, but once activated, it remains in effect through your incapacity and even if you recover from incapacity. It carries the same practical challenges as any springing POA: delays, disputes, and ambiguity around the trigger. A non-durable or ordinary POA takes effect when you sign it but terminates the moment you become incapacitated. This is useful for temporary convenience, authorizing someone to handle a transaction while you're traveling, but it's not a planning tool for a crisis. It stops working at exactly the moment you need it most. How broad is your agent's authority? This dimension applies primarily to the financial side. A general financial POA gives your agent broad authority to handle essentially any financial or legal matter you could handle yourself. Bank accounts, investments, real estate, taxes, contracts, insurance, and more. A special or limited financial POA restricts your agent's authority to a specific task, a specific asset, or a specific time period. For example, you might authorize someone to sign documents at a real estate closing on your behalf, but nothing else. Once the task is done or the time period expires, the authority ends. On the healthcare side, you can also define the scope of your agent's authority. For instance, authorizing them to make most medical decisions but excluding specific treatments. But the general versus special distinction is primarily financial terminology. Most medical POA documents are structured as durable, meaning they take effect when signed, but your agent only exercises authority when a physician determines you've lost decision-making capacity. While you're healthy and competent, you direct your own care. Your agent steps in only when you can't. What makes medical POA effective is the specificity you put into it. You can authorize your agent to make broad healthcare decisions, or you can set boundaries, perhaps authorizing most treatments but excluding specific procedures. You can include instructions about resuscitation, organ donation, and end-of-life care. The more clearly you document your preferences, the less room there is for confusion or family conflict when the moment comes. One thing worth knowing: HIPAA and other privacy laws restrict what medical information your doctors can share with your family. Without proper documentation, your doctors may not be able to discuss your diagnoses, treatment options, or prognosis with the people closest to you, even if they're trying to help. A signed medical POA or a HIPAA release of information consent form ensures your agent can actually communicate with your medical team. Both should be completed while you still have the capacity to sign them. You should also name an alternate agent, a backup in case your first choice is unavailable or unable to serve. And in most jurisdictions, estate planning professionals advise against naming co-agents for medical POA. You don't want two people debating medical decisions at your bedside. Name one person. Name a backup. Keep it clean. On the financial side, most estate planning attorneys recommend a general durable financial POA as the foundation. Broad authority that survives your incapacity. But you have flexibility. If you're uncomfortable granting immediate broad authority, you could opt for a springing structure, though you should understand the delays and complications that can come with it. If you only need someone to handle a single transaction, a special or limited POA may be all that you need. The key is matching the structure to your actual situation. A 30-year-old setting up basic estate planning documents probably needs a general durable financial POA. A business owner who wants one person managing commercial assets and another handling personal finances might use multiple special POAs with clearly defined scopes. Someone who's perfectly healthy and just wants coverage in case of emergency might be drawn to a springing POA, but should weigh that against the practical risks. How many POAs can you have? You can, and generally should, have more than one power of attorney document. Most people need at least a medical power of attorney and a financial power of attorney, and you can name different agents for each based on their strengths. Your son in the medical field handles healthcare decisions. Your daughter, who manages investments, handles finances. Each person operates in their area of expertise. Within a single POA, you can name co-agents, 2 or more people who share authority. But this is where I want to give you a candid warning. Co-agents can be structured in different ways. They can have independent authority, where each can act alone. They can have joint authority, where both must agree on every decision. Or they can have majority authority, where a majority vote rules. In theory, co-agents provide checks and balances, but in practice, they often create gridlock. If 2 agents disagree on a financial decision and the document requires them to act jointly, nothing moves forward. The only resolution may be going to court, which is exactly what the POA was supposed to prevent. Most estate planning attorneys recommend naming the primary agent and one successor agent, a backup who steps in only if the primary agent can serve. If you do name co-agents, be extremely specific about how they share authority, who has final say in which areas, and what happens if they disagree. This brings me to a broader point that applies to every type of POA. You need to be specific about the powers, responsibilities, and limitations you're granting your agent. I'm not going to walk through every clause in this video. That deserves its own deep dive, but I want you to understand why this matters. Your agent has a fiduciary duty to act in your best interest. Keep accurate records, avoid conflicts of interest, and not use your authority for personal gain. But if your POA document is vague about what they can and can't do, you're creating an environment where misunderstandings, overreach, and family conflict can flourish. For example, can your financial agent make gifts from your assets? Can they change the beneficiaries on your insurance policies? Can they sell your house? Can your medical agent refuse a treatment you never discussed with them? If the document doesn't address these questions clearly, the people around you will argue about the answers, possibly in a courtroom. The more clearly you define the scope of authority, the more you protect both yourself and the person you've chosen to act for you. Your POA is not permanent. You can revoke it or update it at any time, as long as you still have the mental capacity to do so. If your circumstances change, you get married, divorced, relocate to a different state, or your relationship with your agent changes, you should revisit your documents. The standard recommendation is to review them every year or 2, or after any major life event. If you want to revoke a POA, the process typically involves creating a written revocation document and notifying your agent, your attorney, your healthcare providers, and any financial institutions that have been working with your agent. Simply drafting a new POA that explicitly revokes all prior versions is often the cleanest approach. And remember, a POA is only valid during your lifetime. The moment you die, your agent's authority ends and your will or trust takes over. Now let me address what happens when someone doesn't have a POA in place and becomes incapacitated. This is a scenario you want to avoid. If you lose the ability to make decisions and you haven't designated an agent, your family may need to petition the court to appoint someone to manage your affairs. This is where guardianship and conservatorship come in. The terminology varies by state, but in general terms, a guardian is appointed by a court to make personal and healthcare decisions for someone who's been declared incompetent. A conservator is appointed to manage that person's financial affairs and property. In some states, these terms are used interchangeably. In others, the distinction is clear. The guardian and conservator can be the same person, or they can be different people. Either way, it requires a formal court proceeding. Someone, usually a family member, files a petition. Medical and sometimes psychiatric evidence of incapacity is presented. The person in question is typically entitled to legal representation and notice. A judge reviews the evidence and decides whether to appoint a guardian or conservator, and which specific rights to remove from that individual. This process is time-consuming, expensive, and emotionally draining, and public record. The court maintains ongoing oversight. Guardians and conservators typically must report to the court annually and may need court approval before making major decisions like selling property. A conservator usually has to post a financial bond. And here's the part that concerns me most as a physician. It can take weeks or months. While that process is playing out, your bills aren't getting paid, your medical decisions may be in limbo, and your family is stuck. A power of attorney avoids all of this. It lets you choose your person, define their authority, and put it in place while you're still healthy, so a judge never has to. For those of you watching from outside the United States, power of attorney is not a uniquely American concept. The principle exists worldwide, but frameworks differ. In England and Wales, you create a lasting power of attorney, registered with the Office of the Public Guardian, one for property and financial affairs, one for health and welfare. In Scotland, it's a continuing power of attorney for finances and a welfare power of attorney for health. In Australia, the terminology varies by state. Enduring power of attorney for financial matters, enduring guardian for healthcare. In Canada, it varies by province. Power of attorney for personal care and power of attorney for property are common. If you have assets or spend significant time in more than one country, legal professionals generally recommend having equivalent documents in each jurisdiction. Power of attorney doesn't always transfer across borders, and financial institutions in one country may not accept a document from another. How do you actually do this? Many states and countries provide free POA forms through government websites, hospitals, or legal aid organizations. In the US, check your state's Attorney General or Health Department website. In the UK, you can create an LPA through the gov.uk website. The basic steps include: you fill in your details, you name your agent, you name a backup agent, you define the scope of authority, you sign it in front of witnesses and a notary as required by your jurisdiction, and share copies with your agent, your doctors, your attorney, and your closest family members. Store originals somewhere safe and accessible. Save digital copies, scanned or photographed, in a secure location as a backup in case the originals are lost or damaged, and tell the people who matter where both the originals and the digital copies are kept. Creating a POA through an online legal service can cost under $50. Working with an attorney costs more, but it's still far less than a guardianship or conservatorship proceeding. And if your situation is at all complex, like multiple assets, blended families, cross-border consideration, an attorney's guidance is worth the investment. A power of attorney is not about losing control. It's about extending your control into situations where you physically can't exercise it. Right now, you manage your own money. You make your own medical decisions. You sign your own documents. A power of attorney doesn't take any of that away. It means that if the day comes when you can't do those things, even temporarily, the person stepping in is someone you chose, someone you briefed, someone who knows how you think. Without these documents, they get stuck, locked out of bank accounts, arguing with hospital administrators, sitting in courtrooms when they should be at your bedside. I've watched it happen, and it's entirely preventable. The people who take the time to set up a power of attorney aren't being pessimistic. They're being practical. And the relief it gives to them and to the people who love them is something you can't appreciate until you've seen what happens without it. So here's my challenge to you. Before the end of this month, do one thing, just one. Look up what forms are available where you live, or pick up the phone and ask someone you trust, would you be willing to be my agent if something happened to me? Or call an attorney and ask what the process looks like in your state or country. You don't need to finish everything in one sitting. You just need to take one step that moves you from, I should do this eventually, to, I've started. If this video gave you clarity on something that felt confusing before, please subscribe. I'm building a library of content on legacy planning, end-of-life preparation, and protecting the people who matter to you. And tell me in the comments, which type of power of attorney surprised you the most? Was there something in this video you hadn't heard of before? I read every comment and I learn from your questions. I'm Dr. Bunchessa. Please plan ahead, protect yourself and your loved ones, and I'll see you in the next one.